think when the lights go on, I'm supposed to say, "Let there be light," or right before. I want to call to order the meeting of the Oklahoma City Human Rights Commission and welcome all of you to our program today and to our meeting. The way that we've organized the meeting today is that first we will have a tenants' rights training, and then we'll take a short break after that and proceed with the items on the agenda, the published agenda. Everyone is welcome to stay for the entire process, and we'll take questions at the very end. It's under our rules, you have to sign up to speak to the commission at the end of the meeting. And Tammy Maxwell has these blue slips that you will provide for her the information on the slip, and then we'll call upon you at the end of the meeting. Let me clarify that during the training, of course, any questions or comments or thoughts are very welcome, and it's only during the business meeting portion of the meeting that we need to follow the procedures established by the commission. So be sure and do that if you'd like to address the commission on any issue that is relevant to our work. We have a new commissioner for Ward 5, and she's not able to be here today, but I did want to just announce to the commission itself that Stephanie Holloway will be serving in Ward 5 commissioner position, the position that Brian Wall previously held. So we will look forward to welcoming her at that time. So I'm going to turn now to our tenants' rights training. And in a minute, I'm going to ask the commissioners to simply come into the seating area of the chamber so that we can learn and enjoy and participate in the training ourselves. So I wanted to, from this position though, welcome Adam Hines, who's going to be facilitating the training. And Adam is at ACLU Oklahoma, and he has been there, at least in part, as a Skadden Fellow who has studied housing inequities in Oklahoma. And he's done research and made presentations about his findings, and we're really fortunate to have him here today. He also worked with the Access to Justice Foundation, again, studying housing inequities and preparing certain papers and findings that we are using ourselves in as we learn more about housing in Oklahoma. We do know that Oklahoma has one of the highest eviction rates in the country, and our commission has been studying these issues for about a year, and we intend to continue focusing on housing, and we'll have additional programs through the year. Adam Hines, I do want to mention one other aspect of his experience, and that is he was a legal extern with Judge Robert Bacharach, a person that I know very well. I served on the court with him, and I think if you know that he's connected to Adam Hines, then that's saying a lot about Adam and his abilities and his heart as well. So I'm going to ask the commissioners at this time to float down to the seating area, and then we'll turn it over to Adam for the program. Thank you.
Thank you. All right, are we all settled? Great. Hi, everyone. My name is Adam Hines. I'm a Skadden Fellow at the ACLU of Oklahoma. I've been there for about a year and a half now. And I'm going to walk you through my Tenant Know Your Rights trainings today. These are some of the questions that we'll answer throughout today's presentation. Does your landlord have to allow a service animal? When can your landlord raise your rent? When and how can your landlord evict you? Maybe some ways to strengthen tenant rights and think about the housing crisis in a tenant-focused way. But before I get into it, I just want to give a little background about why I care about these issues and why I'm here. So I actually grew up, my dad was a landlord. He had a few small properties growing up, and we grew up in a way where between my dad's little small business and the few units that he owned, that's really what paid the bills for us. So I have a lot of sympathy for small mom and pop landlords and for tenants, because I have a lot of tenants in my family who have encountered some really rough outcomes. And it was when I got to law school and ended up doing a legal internship that I was really startled by the lack of procedural protections for tenants in eviction proceedings. And that's when I got really obsessed with this issue about 4 years ago. Started writing about it in law school, then worked with the Access to Justice Commission to do a policy study, got even more obsessed, turned that into a postgraduate fellowship, and that's what I'm here doing now. So that's a little bit about me. Feel free to interrupt at any point. It's not a questions at the end sort of presentation. I want to mix it up, ask questions. I'm sure you'll have things that come up along the way, so just feel free to raise your hand and we'll talk about it. Sound good? Cool. So the first thing I'm going to talk about is security deposits, because I know that's something that affects pretty much every tenant. It's something you're thinking about from the beginning. And the law in Oklahoma is a little unique in this respect. So I think a lot of people will know some of the basics here, but I'll just cover them. You know, your landlord must keep your deposit in a sort of separate escrow account during the pendency of your tenancy, and that means they can't go like mixing your security deposit up with their own funds, because then it's hard to track and know what they have done with it. So that's one piece. After your lease ends, the landlord can use your deposit, this is what it's for, to cover damages, unpaid rent, or other costs described in your lease, but they have to give you an itemized receipt of what they spent it on. So that's something that you have a right to as a tenant and something that you can demand. So if they're going to spend your security deposit on something, they have to give you an itemized receipt outlining what they spent it on. But I think one of the most unique things in Oklahoma is really important to know is that technically under the law, if you want your security deposit back, you have to ask for it back. So make sure, now a lot of landlords are just going to give it back to you, but just demand it back to be absolutely safe, because that is what the law requires to trigger that obligation. So request it back from your landlord. And within 6 months of your lease ending, if you do that, you send them a request for your deposit back. If you do, then they must return it. And if you don't request it back within 6 months, then their obligation could change. So that's a really important piece to keep in mind when you're thinking about your security deposit. Yeah.
You mentioned that the landlord must give a list,
Yes.
and then you said receipts.
Mm.
Are they required to give you the receipts showing the expenses with each one, or can they just simply write a list?
So it's an itemized receipt. So you'll have to have a receipt for each thing they spent it on. So I spent it on this, I spent this much, I spent it to this person. So it's not just a bundle of receipts. It has to be a list of everything that they spent it on. Yeah. Yep.
Cleaning supplies for pets.
Yeah.
Plumbing supplies, you carry the toilet up, you carry the sink up.
Yep.
Anything in the bathroom.
That's right. Just a lot of, carpet cleaning expenses. It's going to be that type of thing that they think they need to spend it on. One of the positives that exists in Oklahoma law, because I want to spend some time on the positives before we get to the negatives and the difficult things, is there are protections for victims of domestic violence in Oklahoma. So if you're a victim of domestic violence, sexual violence, or stalking, you can terminate your lease and move out without penalty. You just have to provide notice to your landlord that you're doing so. I've seen this happen to friends in my personal life, and it's been really important for them that this existed in the law, that they could get out of a place where they no longer felt safe. And I've seen it come up sadly, pretty recently. So this is something to keep in mind. You are not trapped in a lease if you don't feel safe where you live because of domestic violence or stalking. Your landlord can't retaliate against you for it. And then whenever you go to move, wherever you're moving to, your landlord there can't retaliate against you and, refuse to rent to you because you have a stalking problem. They are prohibited from doing so. So that's another positive. And then there are basic accommodations for those with disabilities that landlords have to provide under the law. So a landlord cannot stop a disabled person from making reasonable access-related accommodations at their own cost. So reasonable accommodations that are specific to a person's disability, they can't stop you from making them, but they also don't have to pay for all of them. But there are some basic accommodations that they have to have in any building that has more than 4 units. So this is just some of those. So any large multi-unit property is going to include these and must include them. It's doors that are wide enough to allow for passage of a wheelchair accessible route into and through the dwelling. All the switches have to be in an accessible height. Bathroom walls are enforced. So some basics have to be there depending on the size of the unit. So that's something to keep in mind. And if you are a person living with a disability and you need additional modifications, they can't prohibit you from making those, but they can require you to pay to make them. So that's a good wrinkle.
And there's no grandfathering in for ADA.
Yeah, I don't know the answer to that, I would assume.
There's no such thing as grandfathering in for ADA.
Well, cool. I wish there was. Thanks for letting us know. Yeah.
Go back over that again. You say
Yeah.
if there's certain accommodations that have to be there
Uh-huh.
regardless, and the landlord is responsible for it, right?
Yes. Let me get back to him. Yeah.
4 units and above.
Yes. So these are some of the basics. And I don't know if I've listed every single one here. There's a list of the ones that are required. This is a part of that list. It might be the entire list, but these are some of the ones that have to be there. If you need a second to take it down, happy to pause. Federal law.
So that is the ADA.
Yes. Has everybody got it? So this is another one. This is state law, which is when your landlord can enter your unit. So this is something that happens a lot for tenants as your landlord comes in to change the filters. They want to come in to do routine maintenance. And they do have a right to enter your unit, but they have to give you at least 1 day's notice to enter your unit. So that's why a lot of times you'll get an email or notice from your landlord letting them know that they're coming in the next day. They're required to do that, except in a case of some specific emergency, like there's a pipe burst in the apartment and you're not there. They know that the pipe burst. They know that there's awful damage happening to the apartment. That would be the kind of emergency where they could actually come in without giving you notice. So that's something important to keep in mind. You can refuse your landlord the right to enter, but you're going to have a good reason. So make sure that you have a reason to point to if something's happening. One good reason might be that they didn't give you notice. If they just show up and they gave you 2 hours notice, you didn't know they were coming, there's no emergency, you can refuse them the right to enter.
Notice doesn't have to be in writing, just a call or interview.
So that's one frustrating thing about the Landlord-Tenant Act is sometimes it's pretty specific about notice and other times it's not. So here it's unspecific. I think most of the time it's in writing, but any sort of notice would meet the requirements here. So they called you, they texted you. There's a lot of tenant portals now where your landlord's going to use that to message you because it's going to have a record that stretches all the way back to the beginning of your time there. So a lot of times that's how landlords do it now. It's another piece of federal law, which is the Fair Housing Act. So this is an anti-discrimination in housing law. So this prohibits discrimination in housing based on race, color, religion, national origin, sex, familial status, or disability. So this means that landlords cannot discriminate against you on the basis of this trait in any of these ways. So they can't refuse to rent to you at all because of your religion, because of your race. They cannot set different lease terms for that same reason. They can't threaten, coerce, or intimidate someone just because you're exercising your rights under the Fair Housing Act. So that is another important piece of this. If you think that you or someone you know has suffered discrimination in this way, you can report it to HUD, and they're active in Oklahoma. There's a whole department here that handles those sorts of civil rights violations under the Fair Housing Act, so rely on them if you hear about instances of discrimination. Yeah. Yeah, I don't know specifically under the Fair Housing Act if the courts have said that it does. Sometimes they can be squishy, statute by statute, on what these things include. Greg, do you have?
I think it does cover, there's case law on traditional gender stereotypes and
Mm-hmm.
gender roles, and they fold it in that way.
Yeah.
And there's also been case law, which might not apply as much now, but we've seen cases actually with like HIV sort of based discrimination, not because the person being discriminated against actually had HIV, but they were treated differently just because they were gay, and so it was tied to disability in that way. Even if you're not disabled, but someone treats you differently because you might have a disability, that would fall under the Fair Housing Act. And so they've created sort of LGBT-based pieces to do that as well. But really the gender stereotype thing sort of has captured some of that.
Yeah, and everyone just, oh, go ahead. I was just going to say, everyone in the room who hasn't met him, Greg here is with the Legal Aid Services of Oklahoma. They represent tenants in eviction court every day, and he's a wonderful resource, so I'm sure he'd be happy to talk to people afterwards if you have a moment. They have pamphlets outside about their services, so they're a lovely resource that we're really happy to have here in Oklahoma. Thanks for being here, Greg. Yeah.
Yeah, when you give for someone to talk, would you give them the?
Yeah, of course. Yeah, I'll hand it to Greg. Yes, thank you. You have a question?
How does the new EOs affect this?
It's really hard to know. There's so much uncertainty, and so many of those executive orders are moving through the courts right now that trying to guess at exactly how it's going to affect a specific statute like the Fair Housing Act is pretty next to impossible, sadly. But I will say that it's a statutory act from Congress that the president does not have the power to revoke or edit or amend himself. So I'm hopeful that with all the statutes, and especially things that are as clear-cut as the Fair Housing Act, that those things are preserved and we can continue to rely on them. Yeah.
That's the times that we're living in.
A lot of uncertainty.
Because one of his EOs says there are only two genders. And that's a bunch of nonsense.
Yeah, there's so much uncertainty now. It's one of the hard things with everything to do with federal law is to forecast, because so many of these executive orders and everything is moving through the courts. We will see with time. But let me go back. I'm losing my mouse cursor up here. Where is it? There it is. Yeah, I want to talk about one of the trickiest things under Oklahoma law, which is how you get your landlord to make repairs and how you request repairs in a formal way that you can rely on. So before I get into all the details here, I'll just say that there are some things to be cautious about as a tenant when you're thinking about repairs, which is that there is no anti-retaliation protection in Oklahoma for tenants. So what that means is that if a landlord wants to, they can retaliate against you for requesting repairs, and there's not much you can do about it. So sadly, this does happen in Oklahoma. There was actually a excellent but heartbreaking Oklahoma Watch story from just a few weeks ago that outlined a lot of instances of retaliation. Typically, this happens with people who are on a month-to-month lease, and I'll talk about that a little later, but in Oklahoma, if you don't have a lease agreement, you default into a month-to-month lease. And if you're on a month-to-month lease, your landlord only has to give you 30 days notice to terminate your lease. So what's happened to a lot of people in Oklahoma is they're on a month-to-month lease with their landlord, and they have some really dangerous issue going on in their home, whether that be a really bad mold infestation, lack of AC in the middle of the summer, and they request and request and request and get nothing. And eventually, if the landlord doesn't want to do anything, they can just evict you with 30 days notice because you're on a month-to-month tenancy. So that does happen in Oklahoma. So I would say if you're someone who is on a month-to-month tenancy and you don't trust your landlord for some reason, it's worth moving cautiously through these steps because there aren't very many, really any anti-retaliation protections to protect you in that situation. The other reason that you should be cautious is that Oklahoma has an overriding duty to pay rent. So you cannot stop paying your rent and remain in your unit because of a maintenance issue in Oklahoma. So if you're behind on rent at all, your landlord can evict you. You might be in a situation, I've heard of tenants in this situation, where you're behind on rent, but your landlord is being lenient for the time being, hasn't started eviction proceedings, but you're living in really, really bad conditions. And you decide to start pushing it and requesting repairs, and then your landlord can evict you just because you're behind on rent, and those repair issues aren't going to save you or stop you from that outcome.
Is this typical, like across the nation? Are there other states where you can stop paying rent?
Yeah, so Oklahoma is only one of 6 states in the entire country that doesn't have anti-retaliation protections. So we're really in the minority here, and it's quite sad.
I've seen a lot of Section 8, that happens a lot of Section 8 people.
Mm-hmm.
And they don't care. They get people in there. It's a revolving door. People get in there, and then if they get evicted, they lose their vouchers for Section 8.
Yeah, it's heartbreaking. It's really bad outcomes sometimes. Did I see some other questions? Yes.
You said that if you terminate the lease within 20 days,
Mm-hmm.
but if you have rights and you within 5 days. You told me, by the way, Texas.
Oh, you're okay.
This was kind of really shocking to me to discover
Yeah.
the housing situation.
Yeah, so the timeline is different. Yeah, of course, of course. So I think you just asked that you'd heard that some landlords can evict you within 5 days. So I think it's different depending on what's going on. So I'll talk a little bit more about the eviction timeline if you're behind on rent, which is a very specific timeline. It's still not within 5 days. What I'm talking about with retaliation and a month-to-month rent is a scenario where once you've defaulted into a month-to-month lease, or you could just have a month-to-month lease with your landlord where you have no lease agreement or you agreed to just go month-to-month, you don't have any tenancy that lasts for a year or more, then your landlord just has the power to terminate your lease for any reason with 30 days notice. So they can say, you have to be out within 30 days. I'm telling you on May 1st, you have to be out by the end of the month. And they don't need a reason for it. It's different when they have a reason to evict you. That's most often because you're behind on rent. And I'll talk about that timeline a little later, but it's also specific. So the most important thing when you're working through requesting repairs and what process to take is to take it step by step to make sure that you're being as cautious and precise as possible. There are a lot of steps here, but I also have a pamphlet, I have a bunch of them with me and outside that will walk you through the steps, and you can share those with people and rely on them, and it'll sort of show you step by step through the law which direction to go to make sure you're being as careful as you can. I think the first thing that's most important to do is if you're looking at a repair issue is to think about how severe is this issue, because the severity of the issue is going to help decide what options you have and what approach you should take to it. So the first type of issue is a mild maintenance issue. So this is something that doesn't affect your health or safety. It's a leaky faucet, it's a broken dishwasher. It's an issue, it's an annoyance, you need to get it fixed, but it's not affecting your health or safety, it's not an essential service. It also could be a moderate issue. It could affect your health or safety. It could be a missing handrail, pests in the apartment, things like that. The trouble with these moderate ones is that these kinds of issues aren't clearly defined under Oklahoma law. So it's if it has some material threat to your health or safety. So that can be defined by you. Eventually, if it becomes an issue in the courtroom, that's going to be something that you're going to argue back and forth with the judge if this does have a material threat to your health or safety. But things like missing handrails, pests, a really severe mold infestation, these are the sorts of things that could fit into that category of issue. And then the most severe is a lack of an essential service. So these are things that are defined under Oklahoma law that the landlord has a responsibility to provide for you. So they have an affirmative responsibility to provide this for you and make sure you have it. And that's heat, running water, hot water, electricity, or gas. So all of those things are essential services. So first identify the issue. And then after you do that, you want to make a formal request in writing. And the way you make this request is important. So a lot of Oklahoma judges are going to expect physical writings in the form of paper letters and mail. It sort of depends on where you are. So I know here in Oklahoma County, the judges here are willing to accept electronic forms of written notice, like email and text messages. But I've seen judges in other parts of the state who aren't willing to accept that and who really want to see physical notice that you got it to your landlord. So if you want to be extra safe, if you don't live in Oklahoma County, following through with something like certified mail, which makes sure that you have proof that your landlord got that notice and it got to them. Another pretty reliable way is through your tenant portal. So a lot of people have tenant portals now where you can communicate back and forth with your landlord. That can be a really reliable way. So I would just steer clear of things like text messages and phone calls. So things that are like easy to prove that you told your landlord about this. So an email is going to be better than a text message or a phone call. And if you can do a physical letter, that's wonderful, or go through your tenant portal. It's going to be a powerful way. And one caution here is I'm going to talk about in just a moment some of the different remedies you have, ways you can fix this issue. One of them is to repair and deduct yourself. If you're planning on repair and deducting, if that's an option for you, that you're going to hire someone to fix it and deduct it from the rent, just tell them in this first notice. Say, if you can't fix this, I'm going to go ahead and have somebody repair it and deduct it from the rent myself. So they're on notice about that. Yeah, go ahead.
Does the tenant have the burden of showing that the problem is materially affecting their health now, or is it like a potential for it?
So it would be materially affecting your health in the moment. So that something that's materially affecting your health in the unit right now. So if you have a really severe mold infestation, but I think a lot of these things are sort of squishy under the law when you get into the courtroom and you're arguing these things with the judge if you have to. And that's why this sort of general definition can be kind of difficult for tenants and for judges to grapple with, is what poses a material danger to your health or not can be tricky. Greg deals with these things a lot. I mean, what other detail do you think you have there? I'll give you the mic.
Oh, sorry. It's usually pretty clear cut. Like if there's no heat, then the judge will just, take that. They don't make us connect the dots to sort of health. In the case of mold or bed bugs are two things that come up fairly often. They don't question how that would materially affect somebody's health. Well, sometimes mold, because sometimes some mold is worse than other mold, and sometimes the clients don't come with clear pictures. And then there's also a causation issue with bed bugs and with mold. Who caused it? Usually mold, it's easier maybe to put on the condition of the apartment as a whole, or maybe that was there beforehand. But sometimes landlords will say, well, the tenant brought the bed bugs in with their furniture or something like that. So that's the tricky part, but usually judges don't trip us up on the how is it affecting your health issue.
So what if it's something like a missing handrail that could cause a fall? You haven't fallen, it's clear that you could fall without help.
So I haven't had to argue something like that, but I think especially if we showed that for this tenant and this landlord knew this tenant needed that, I think our judges would go along with that, would agree that that's essential.
Yeah, and I think, oh, yeah, of course. Yeah.
The office makes it physically difficult for you to present yourself. So how do we deliver this letter and who do we address it to?
Yeah, I think if it's difficult to get in contact with them, I think certified mail can be a really great option, because then they will bring it to them directly and ask for their signature, so knowing where they are and getting a hold of them. If they're not there present in the office, just doing everything you can. So sending certified mail, texting them, emailing them through the tenant portal, so to just like cover all your bases so that you can say, well, I tried sending certified mail, they weren't there, I couldn't get it to them, so I emailed them, so I texted them. Having all these fallbacks will be helpful. Yeah.
What about the corporate landlords that's either out of state or out of the country? How do you handle those?
Yeah, they just asked about corporate landlords who are out of the country or out of the state who are hard to get a hold of. So that's a real problem in Oklahoma. There's more and more corporate landlords who are sort of running and owning even many, many homes, single-family homes that are for rent or owned by corporations. So then, most often, there's going to be a local property manager, especially at a multi-unit property, that you can get a hold of that does have an address. And one of the nice things is a lot of these corporate landlords are going to rely on tenant portals. So that's a way that you can reach them through the tenant portal and have record that you message them. So that's a really good fallback. So it's really just a hierarchy of if you can reach them with certified mail, if you can reach them with a physical letter, do it. If you can't, your tenant portal, email, text, fall back on these other things, and be ready if you end up having to defend this issue in court to say, I couldn't find them, I tried to find them. There's a lot of things with notice is that you made reasonable efforts to notify them. Like I did everything I could, and I couldn't reach them, so I did this other thing. And showing the court that you made all these reasonable efforts is what's gonna make the difference. Okay.
So in the event that you give them this notice and you say, I'm planning, if you're not gonna fix this, I'm gonna fix it, I'm gonna adopt it from the land. One, what are the protections for that? Two, what is like, if that were to go to court, what is like the burden of proof, probably not the right word, but how do you prove, or like how often is it argued, well, like this repair cost too much? So the tenant fixed it for $800 and we would have fixed it for $200. Like how does that get calculated?
Yeah, so he asked about repair and deduct and how you navigate that in the courtroom. So if you're arguing about whether or not it's reasonable or not, you got a reasonable cost, like maybe you had to fix a broken window and you paid $800 for that broken window, and the landlord says, well, I could have gotten that done for $500. That's not reasonable. These are the sort of squishy back and forth issues that are going to come up in the court and be argued. I think that's why finding a reasonable person, a professional to do it, is really important, and having receipts. That way you can point to, well, this is a reputable repairman in Oklahoma City. He charges this cost to everyone. That's a reasonable price. I didn't go out and just find my cousin to do it, and he did it for extra money so that I could deduct that from my rent. That's why it's so important to go to someone who's a professional in the community who's been doing it a while, because that's really going to back you up in the courtroom. Did I see some other questions?
Yeah, the repair,
Yeah.
can you do that just immediately? I mean, can I send them that certified letter?
Mhm.
Tell them I'm going to do it. I mean, I can take the bull by the horn myself as a tenant. I don't have to get their approval to do that.
Yeah, so they're asking if you can just immediately repair and deduct or if you need to wait. You do need to wait, and I'm about to get into that. So that's sort of a timeline that you'll go through step by step. So step 3. So I'm going to take this by the type of issue. So for a mild issue, so this is an issue like we talked about earlier, sorry about that. This is all maintenance issues. You can do this for any maintenance issue, mild, moderate, severe. So if your landlord doesn't address the issue within 14 days, so you give them notice, you wait 2 weeks. Now, if it's an emergency, you can move a little faster. Like say you're lacking an essential service, you don't have heat in the middle of a really awful cold freeze in the winter, that could be an emergency. But typically, it's 2 weeks. And then you have a few options. So for all of the issues, you can do this. So regardless of how mild or moderate or severe the issue is, if it violates local building codes in your municipality, you can contact the municipality and let them know about the housing code issue, ask them to come out. And if the issue is severe, if it violates local housing codes, they can issue citations to your landlord. I will say that this is something to be cautious about. Really, I'll get to in just a second, I'll finish this bit. One thing that's sad is even if they're piling up code violations at your landlord could still just evict you. And that has happened to people who were on a month-to-month tenancy. And this actually happened in Tulsa last summer, where they didn't have AC. It was sweltering hot. They were really suffering in the room, in the apartment. They eventually went to the city. The city came out. They cited the landlord, and the landlord got fed up with it and just evicted them because they were on a month-to-month tenancy, and they can just evict you with 30 days notice. And there's also been some really sad outcomes. In Midwest City, there was an apartment complex that was in such awful condition for so long that when the city did get involved, they tried over and over and over again, citing the landlord, asking them to make repairs, and they refused to do it. So eventually they had to condemn the building, and everyone there sort of lost their homes, which was pretty sad. But that was also a landlord, that was a corporate landlord from California that just happened to own the building and did not care to make those repairs. And yes, you had a question earlier.
If you have a problem within the city limits of Oklahoma City, you can call the ACT Center. They will help you.
And it's the ACT Center, you said?
ACT Center,
Thank you.
the Action Center.
So for a moderate issue, so this is moderate and severe issue, these are some options that you have as a tenant. Again, you're gonna have to wait 14 days or fewer if it's an emergency. So say 14 days have passed, you have a moderate or severe issue. Providing them with a second written letter to your landlord, so notifying them that you're terminating your lease. So you have the ability to terminate and leave if it's a moderate or severe issue. So this has to be an essential service that's listed on the list, or this has to be something that poses a material threat to your health or safety. But you're going to have to provide them a second letter letting them know that this problem was not resolved. I let you know about it 2 weeks ago. It poses a material threat to my health or safety. I'm going to terminate and leave. And then you have to actually leave within 30 days and vacate the unit. This is a possibility, but you have to make sure to follow through with that second notice to your landlord and make sure to document everything really thoroughly, because if you terminate your lease and leave, your landlord can argue that you've violated the lease terms and take you to court for that back rent for violating your lease. So this is one of those areas where being really precise is really important, because if you end up in court on this issue, being able to prove that you gave the proper notice, you waited 2 weeks, you gave an additional notice, you included all the relevant detail is gonna be really important for a tenant. But a lot of tenants can't really terminate and leave, especially if you're a low-income tenant. So this ends up being a non-starter for a lot of people. We have such a affordable housing shortage in Oklahoma City and Oklahoma generally that a lot of times terminating and leaving isn't a real option because there's not very many places to go. So these other options can be more helpful, but they are also difficult to pull off, sadly. So the second one is to notify your landlord in writing that you'll be addressing the repair and deducting the cost from your rent. So this is, again, you have to wait 14 days from that initial notice. And now it's been 14 days, and now you have to let them know, it's been 14 days, you didn't fix this, I'm going to hire a professional to do it for a reasonable price, to repair it and deduct it from the rent. Like I said earlier, you need to make sure you hire a professional to perform all this work, get a reasonable price, and keep your receipts. So you can provide those to the landlord to prove what you're deducting from the rent. One of the most important caveats for repair and deduct is that you can only do this for 1 month's rent, which is a pretty tricky piece of it, because depending on where you live, a lot of these issues that are a material threat to your health or safety or a severe issue are gonna be more than 1 month's rent. So if you have a busted out window and that the best price you can find to fix that window is $900, but your rent is only $600 a month, you can't repair and deduct all of that because it can only go up to 1 month's rent. So that's a big limitation on repair and deduct right now.
On the housing issue that you're talking about, for ADA, it's even worse.
Yeah.
Because for probably 5-6 years, I kept trying to ask the city council to get these developers to divulge how many ADA units they have in their building, and they would not do that.
just making the point that there's a lot of units that, or a lot of developers that aren't letting people know how many ADA units they have, and if you're looking for an ADA unit, that can be really, really tricky. But to move on to the last set of options that you have. So these are only options that you have if there's an essential service that's not being provided to your unit. So there's a specific list of what essential services are in the statute, and it's lack of heat, running water, electricity, or gas, or hot water. So if you don't have one of those issues, if you're lacking that service, you have some more options, but you still need to be careful and walk through these. Again, you have to wait 14 days or fewer in an emergency. I think when you're lacking an essential service, it's more likely to be an emergency, especially depending on the time of year, like lacking heat in the middle of the winter. But first, you can, and this is one of the trickiest remedies in the law. I don't know if I've ever heard of anyone successfully pulling this off, but you can technically do it. And that's to notify your landlord in writing that you're temporarily vacating the unit, and that you will not pay rent until the essential service is restored. And in that notice, you have to include updated contact information, because you're leaving the unit, and tell them where you're going. That way they know where you're going. So you have to be really careful and include that, because if you don't and you just vacate and go away and the landlord can't find you anymore, they can say, well, you just broke the lease terms, you didn't tell me where to find you, you're now in violation of the lease, and I can sue you for terminating the lease agreement, back rent, the remainder of the rent, all those sorts of things. So be sure, if you were to try this, to include updated contact information in the notice. And then if you decide to eventually terminate your lease in full, like one of those options we talked about earlier, you're gonna have to give another notice to do that. But this is a tricky one. Only temporarily vacate. I haven't heard of anyone successfully doing it before because it's so tricky. The second one is to stay in your unit and sue your landlord for damages to the unit's fair market value. It's technically an option under Oklahoma law. It's not something you should do without the assistance of an attorney. So if you find yourself in a situation like this, reaching out to an attorney, reaching out to legal aid, going through their intake process is going to be the best option for you, because you have to move through this very precisely if you want to do it right and be safe. The last one is that this is another exception to repair and deduct. You can notify your landlord in writing that you're going to hire a professional to restore this essential service for a reasonable price. And in this instance, that 1 month cap doesn't apply. So if you lack an essential service, you can repair and deduct more than 1 month's rent, but only to restore that essential service. So if you don't have electricity and you've waited 2 weeks and you don't have it, you can pay a reasonable price that's over 1 month's rent and repair and deduct it, but only for these sort of essential service issues.
And that rolls over, like if my rent is 1,000 and it's 1,500 to repair and deduct for a severe issue, like not pay the first month and then 500%.
Yep. Like I said, it's just going to be essential to go through all of these notice processes and have all of your receipts to prove that to your landlord. Because if you don't have it, they can argue that you're delinquent on your rent, that you refuse to pay rent, that you're in violation of the lease, and then you could end up in eviction court. So you just got to cross all your T's and dot all your I's on those issues. Mm-hmm. Yeah, it's a good question. What's the intent? These parts of the Landlord-Tenant Act have not been updated in decades. They're quite archaic, and there's so many frustrating bits here that make it hard for tenants to navigate. You can guess at all the reasons why that might be when the law was passed in the state, but it certainly hurts tenants now because it's really hard to navigate these issues without the assistance of an attorney. And tenants in certain parts of the state, like parts of Oklahoma City and Tulsa, are lucky enough to have legal aid there to represent them, but many tenants throughout the state don't have that luxury and don't have someone to represent them and work through these processes. That's why I think it's so important to do tenant education events like these, and why I created those pamphlets so that there's a step-by-step process to work through them. But it needs to be, a policy priority for those people who care about tenant rights to sort of clarify these issues, include more plain language in the law, and more remedies for tenants. So it's easier for them to move through this issue without all these potential roadblocks.
So the follow-up to that is how you
It's a great question. I'll hand that one over to Greg.
So for legal aid, our team is shrinking a little bit here in Oklahoma County. We're still going to every docket every day. We're still trying to take as many tenants at the docket if they apply in person as we can. But we're shrinking to the point where some days we have to cut that off. And we're doing things like prioritizing certain things. If somebody's on Section 8 or somebody's a public housing tenant, we prioritize those cases because it's not just the immediate eviction that's at stake, it's their ability to maintain or to access other subsidized housing. If you get evicted while you're on Section 8 or if you get evicted from public housing, you can be locked out of all subsidized housing for the next 3 years. So we are prioritizing in certain ways like that. We're still doing what we can, but our executive director and people in our admin are working on securing future funding. And we've gotten some extra funding here and there. We have a little extra ARPA grant from the county that's kicked in that we're using for the next year. And I think that's eligible to be extended by another year. So hopefully that'll come into play. And we have a few other things in the works. But yeah, there was some, that initial wave of COVID era funding really boosted us. And some of that is going away now. And we're trying to work on replacing it, but I don't have any solid details about actual replacement funding right now.
Are there philanthropic efforts for legal aid?
Yes, yeah. I mean, we're always talking to the big private foundations as well, and other people are getting involved too. OCU added an extra attorney for their clinic, and we work with them, and they're at the docket just about every day now as well. And then NSO is working on, they're sort of designing a new landlord-tenant resource program. I don't know if they have all the details on that yet, but we're working with them and they're getting involved too.
Just one last thing. I think that what's important is housing instability has greater implications for health, for mental health, for various aspects of people's lives. So it's not just, I lost my housing, it's I lost my job, I don't have anywhere to stay, which has, my kids can't go to the school that they're in. So we really have to figure out a way to fix this problem.
Yeah, absolutely. And it is educating people on that. And luckily for the children in schools, we have the McKinney-Vento Act, and we advise people on that. And the school districts are obligated to help maintain those kids in their original school. Even if somebody's evicted and has to move 3 districts away, the districts have to coordinate and keep those children. So there are certain things that help with the disruption, but eviction is very disruptive to families and to their neighbors and to neighborhoods.
Yeah, go ahead. Thank you, Greg.
Yeah, you mentioned that the Landlord-Tenant Act is archaic. I'm presuming it's a state.
Yes, it's all state law.
So is anybody getting with some legislators about updating it?
Yeah, there's been a lot of ongoing efforts over the past few years to update different parts of the Residential Landlord-Tenant Act. There's a few bills in the legislature this session. There's one actually that I think is going to be heard on the Senate floor today, which is Senate Bill 128, I believe, which would extend the eviction timeline, which is something I'll talk about here in a minute. There was another bill that sadly didn't get a vote in committee that would have added additional tenant remedies, so it would have added new things to this list up here to address that issue. So there are efforts going on. I think some of the most important things is just as a tenant, as someone who cares about these issues, reaching out to your legislator and talking to them and telling them your story. I think that's the most important thing. A lot of landlords have concerns and are reaching out and talking to their legislators about it, hearing from tenants, talking about your issues, telling your story. That's really important and powerful. I'll add one more bit on the discussion that we were having about the impact of evictions, and just that, sadly, research shows that the group that's most often evicted in the United States are single moms with children, and that, sadly, one of the things that correlates most with the neighborhood's rate of evictions is the number of children in that neighborhood. So this is a real issue that affects children and families and has a really detrimental effect on communities. So it's a reason to care. But now I want to talk about when and how your landlord can raise your rent. So your landlord cannot raise your rent in the middle of your lease. So if you have a contractual agreement about the amount of rent that you're going to be paying, they can't raise it in the middle of your lease. That'd be violating the contract. But at the end of your lease, your landlord can raise the rent to whatever amount they want. There's no legal limit on that in Oklahoma. So if your landlord raises your rent to a price that you can't pay and you have to go, that's just the reality in Oklahoma under Oklahoma law. There's nothing to be done. But say, for example, you sign a 1-year lease at $750 a month. Your landlord cannot demand more than $750 a month for that year. But then at the end of your 1-year lease, they could raise it to any amount they'd like. This is something I was talking about earlier. Can your landlord decide not to renew your lease? Yes, but they have to give you notice depending on what type of lease you have. So if you have less than a month lease, which is pretty rare because under Oklahoma law, you're gonna default, you're gonna automatically be in a month-to-month if you don't have a lease. But if for some reason you've agreed to be on a less than month lease, your landlord's just gonna have to give you 7 days notice to get out of there. If it's a month-to-month lease, which a lot of people find themselves on, because that's what it's automatically going to default to if you don't have a lease. So say you have a lease, you end up staying over on your lease, you've been there a year, but you stay over, your landlord lets you stay over, but you never sign a new lease, you're on a month-to-month lease. That's something really important to know. And on a month-to-month, your landlord only has to give you 30 days notice to get out of there. If it's a year or more, then they have to give you 3 months notice. Yeah. I don't think there's anything that would keep them from doing that unless it's, obvious that they're doing it in a discriminatory way based on one of those. Yeah. If it's retaliatory, because there's no anti-retaliation protections, there's nothing to protect you. And a lot of units, they can point to say, well, this unit's a little nicer than the other one, so we're charging you more for that reason. This one has updated appliances and things like that. But I don't think there's anything to protect tenants on that level. Go ahead. Typically, that's typically what they do. No, that's typically what they do. I don't think that they're required by the statute to give you 3 months lease on that point, but that's typically what landlords do. I think that 30 days notices, it might be more than that, but I know that's typical practice. Okay, good to know. Fair enough. Okay, let's talk about when your landlord can evict you. So your landlord can evict you for the following reasons. You have not paid rent, very common one. You have broken rules outlined in your lease. That includes involvement in criminal activity, things like that. You have created a danger for other people in the building. Sometimes that can be defined pretty broadly and defines on your lease terms. So read your lease really closely. That's a really, really important piece of this, is to, yeah, go ahead.
If the latter one is not well defined in the lease, how does that typically play out in the court setting? Is that more, or judge more deference to the landlord on that? Like, what's the burden?
I'll let Greg answer that question since he's probably dealt with this a lot more in the courtroom.
Creating a danger for other people. I had an interesting case that we still need to finish, where one of Robert's clients evicted. They won in a hearing. We had a contested hearing on it because they said my client was triggering the smoke alarm. There was an incident where my client apparently, she didn't testify to this in court, but other people said that they told her she set a dish towel on fire or it started to smoke.
and that was the key incident. And the judge decided that they don't have to wait for an actual fire, that the risk was there. Am I misstating this, or?
Well, if you want to get into the facts of the case, she had a wet dishway that she held over an open flame that either caught on fire or smoldered.
I don't think anybody knew she held it over an open flame. I don't think there was any.
That's what the testimony was from what
No.
she told another tenant. You know, we have 82 people in that.
But there was also testimony that other people set off the smoke alarms, and those smoke alarms are pretty sensitive. And there was you brought some pictures of cosmetic damage at best, almost no damage whatsoever. And we had no idea if those pictures were actually caused by the alleged incident. We couldn't establish that.
Well, everybody, if you're wondering what the picture board looks like, this is what it's like. We're lucky enough to have someone who represents landlords and tenants in the room.
There was so much more to this case than what you just said there.
That was the key issue.
And I want to tell you that in that case, just so that there's not such a bad slant on the landlord here, we had 82 people living in there. She was doing something that the judge found was inappropriate, causing potential problems for all the people in the property. She lost the case. The landlord had offered, in that case, to let her stay for 30 days and find someplace else that was more appropriate for her because she had some other issues going on. She refused that offer, and after the landlord won the case, we went back and said, we'll still give you 30 days to get out so you can find another place. So I just wanted to say that in fairness, you know, we did a lot we could in order to accommodate her, number one, and for her not to lose any subsidized housing that she would have had. She needed to go someplace else. Even the judge felt that she needed to be in a different type of setting than what she was in, and felt that there was a necessity there to save a potential disaster at that property. In cases like that, I can't lose those cases. Even if the judge says, okay, we're going to let her stay, I'm in a position, or my clients are at that point, that, and I don't mean to be doing this, but it was brought up. I'm in a position where I have to protect every tenant in there, not just her. And then I've got to go on the position that if I don't do something to protect those other tenants, God forbid there is another incident where maybe there is a catastrophe there. Everybody's going to be looking at the management company and saying, well, why didn't you do something before?
Mm-hmm.
By doing what we did, potentially, even if I lost the case, if something happened later on, and I was faced with 12 independent people on a jury that were going to determine whether or not my client acted judiciously in trying to remedy a potentially serious situation, we would be able to at least say, you know, just
Yeah.
that people who brought that before a judge.
Yeah. Mm-hmm. Yeah. Yeah, I think.
There are fair housing people have actually set fire to their apartments and gotten reasonable accommodations because their medication had changed, this or that.
Yeah.
To say that I should still have access to housing and they've won those fair housing cases.
Yeah. There's. I think it's. Yeah. I think it is important to point out that, you know, we're talking about tenants' rights here and what the tenant's perspective. There is a landlord's perspective to all of this, and there's many, many mom and pop landlords in Oklahoma who struggle with real issues. My dad is one of them. He still struggles with real issues renting places in small town Oklahoma. So they have real interests here, and I can assure you their interests are well represented and advocated for. So got to talk about both sides of the aisle, and they will fight it out, as you've seen here in the room today. But yes, go ahead.
For the second one, I assume that this usually promotes like gang activity. How broad is this, and what is the burden of proof from the court? Like, do you have to charge a tribe with something? Can they just suspect?
No. Yeah, this is one of the kind of strange inconsistencies here. So it's a pretty broad definition that they're allowed to have for criminal activity. And the burden of proof is a preponderance of the evidence in small claims court in evictions, which, typically you don't want to assign percentages, but in law school they tell you that's 51%. So it's more likely than not that it happened. So you can end up in situations here where you have to prove that it's more likely than not there was criminal activity, which is pretty different than beyond a reasonable doubt, which is what you would be proving in a criminal case. So that divide can cause some real issues. Did you have a question? Mm-hmm.
Is, what does, other tenants have, relief for, the management, not doing enough to, make others feel safe in the building? Because I'm in a unique situation with, housing.
Yeah, so the question was what rights other tenants have to talk to management if they don't feel safe in the building because of what other tenants are doing?
Management not doing anything.
With the management not doing anything. So typically, the question was if the management's not doing anything to talk to these other people. So almost always in your lease, every tenant is going to have an obligation not to make the space dangerous or threatening for other tenants. And the landlord has an obligation to preserve that and make sure that it's a safe place. So just like he was saying earlier, that's something that he has to think about with his clients who are landlords. They have to live up to that obligation in the lease. So that's something that you want to double check your lease, if that obligation exists for management, to remind them of it, that they need to be living up to that. So this is the timeline question. So if you're behind on rent and your landlord decides to evict you, how much time do you have? So the timeline here can be a little tricky to hash out if you don't know all the places in the statutes to look, because you have to look in 3 to 4 different places to really hash out everything. But what I want to show you is just the timeline so you can see how it breaks down. So this is the quickest possible timeline that someone could be evicted under Oklahoma law. It doesn't mean it's the typical timeline, because typically there's delays that happen along the way. But if you were taking the fastest possible route through the statutes, it would go like this. So your rent would be due on the 1st. You're behind on rent. You get a notice to pay or quit from your landlord on the 2nd because you're behind on rent. Your landlord's going to wait 5 days to file for an eviction. So you have time to cure in these 5 days. So in these 5 days, if you come up with the rent and you pay your landlord and you're back up to date, you can prevent the eviction filing. But if you don't, that eviction is filed by the landlord. Now they're going to set the court date between 5 and 10 days after that. So if we assume it's 5 days after that, it's going to be on the 12th of the month. So that's when your court date will be, when you'll have to be in court, where the judge will decide. And you'll get notice for that at least 3 days before. That's what the statute currently requires. So that's on the 9th. So you have 3 days notice that you have court on the 12th. And then if the judge grants the eviction, if you're behind on rent, very likely to happen because of the overriding duty to pay rent in Oklahoma, then they could order the writ of execution, which is what allow the sheriff to remove you. And once the sheriff has posted that, you have 48 hours to vacate the premises or they will come remove you. So this is the quickest possible way. That doesn't mean it's typically what happens. This is something that looks more like a typical timeline in Oklahoma, which is say your rent's due on the 1st, your landlord maybe waits a day, you don't get that notice to quit until the 3rd, then they file for eviction on the 8th, you get your summons on the 12th, and your court date isn't set until the 16th. And not always is the judge going to issue the writ the day of. It might be a few days later. You might have a weekend between having court during the week and the next one. And the sheriff might be a little late getting out there. So you might have somewhere from the 18th to the 24th until you're removed. Yes, sir, in the back.
We have to leave now.
Yeah.
Is it possible for us to get an email address and you email us all this
Yeah, absolutely. One thing. Yeah, if we have somewhere that we can get people's information down, I'd be happy to share the slides with people. Do we have a paper where people can write down their information? Yeah, thank you very much. So the last thing I want to talk about is just pet and support animals. To pause on something positive here, because I think we all love our pets, and we can all agree about that. We love our pets, whether we're landlords or tenants. We care about them. So if you have a pet support animal, emotional support animal, there are some protections for you and your pet under Oklahoma law, but you have to meet the requirements. So say you're blind, deaf, or physically handicapped in some way, then your landlord must allow you a service dog as a reasonable accommodation to your disability. It's under Oklahoma and federal law. But if you have a disability that's not readily apparent, so this is a mental illness, something that's not readily apparent to your landlord, then your landlord can require that you provide documentation of your disability that requires the animal. It usually includes, typically must include, not typically, it must, under the Oklahoma statute. You can have to describe the disability in the letter, how it substantially limits one or more of your major life activities, describes the needed accommodation with the animal, shows the relationship between the disability and your needed support. And if you do that, then your landlord has to allow it as an accommodation. But that's my last point before I move on to Q&A and some of the last things. But I'll just say, we talked about a lot today, some of the positives that there are and negatives, and thinking about strengthening housing rights for tenants. If you care about these things, these are some of the things you can advocate for. Things like anti-retaliation protections we talked about today. That's something that has to happen at the state level, at the state capitol. It's going to take political will on the behalf of a lot of legislators. I'll get to you in just a second. Housing code enforcement and things happening at the city level. I know this is something the city council is aware of and cares about, but making sure they know that you care about it, and that robust housing code enforcement and finding ways to make sure that the places where tenants live are safe and sanitary places. And then zoning changes is one that's on here just because we talk about affordable housing supply and being able to build enough affordable housing and enough housing, period. And that's something that zoning can cause real tricky problems for, because there's just not enough space to build multi-unit properties in Oklahoma. And that's something that has to happen at the city level and is incredibly difficult, because everyone has strong opinions about zoning, as I'm sure everyone involved at City Hall can tell you. But these are all issues that we have to care about if we want to resolve these issues. But with that, that's all I got. Does anyone have some questions? Yeah. Yeah, I think just following up over and over again with your elected representative, and then following organizations that care about these issues. At the State House, we have a bill tracker on our website. It has a housing bill tab, and you can follow that tab and see, has something made it through committee? What does this bill do? Who authored the bill? And that'll make it easier for you to call your representative and let them know that you support it. So following organizations that track these things and following up with your own representative is important. But I want to get back to you because you were waiting earlier.
Your previous slide is called Invisible Disabilities.
Yes.
Actually,
Yeah, it's very important. They're very real. They affect millions of Americans, and that's why there should be legal protections for them. Yes.
That website, the Bill Tracker, what is the URL of that?
It's on acluok.org, and
You go to acluok.org and then you should click on our work in legislative session, and there's a tracker right there. But if you give me your email, I can email it directly to you as well.
that's good. Yes. Yeah.
What is happening is there are these verbiage high traffic. They're telling me that my tenant must go because of the high traffic. Now, they're not staying the night, they're just coming in during the day. And then they're saying they must leave immediately or they will pull our master leases for the entire property. Is that legal?
I'll give Greg the
Who are you with? Are you with like Homeless Alliance or mental health? Okay. I had a case recently where, the Mental Health Association was saying that the apartment complex was threatening all of the mental health associations' contracts because of this one tenant. But no, high traffic, no. That in and of itself, if somebody lives there, you can have as many guests as you want. Like, it's your home. So some people try to frame it as in, well, we suspect they're selling drugs or something. Why do they have all this high traffic? But they need more proof than that. And sometimes when people use phrases like that, I don't know, alarms go off, or like, are they getting at some discriminatory thing and they just aren't saying it? So that's, especially for mental health association clients, they're susceptible to discrimination because of, their mental health issues. So yeah, we can talk. I'd be on the lookout for that.
Any other last questions? I'm sure we've gone long. I'm sorry about that. Any other questions? Not seeing any. Well, thank you all so much for coming out and listening to me go on for so long. And, thank you. And like I said, we have pamphlets outside that walk through some of that information if you'd like it, so feel free to grab it. Thank you.
Adam, thank you so much for being here with us this morning. You have so much information. You could probably spend the whole morning with us and we would still be asking questions. But I want to thank Greg Beeben and Robert Goldman also for being here, because they're such experts in this area and wonderful resources for our community. Thanks to all of you as well. We will have another tenant rights training in April, and that information will be publicized if you would like to come again. Adam is going to accommodate us for another event, and we appreciate that. One thing that I have kind of a takeaway from this is how complex this area is. And it's hard for tenants sometimes to navigate an uncertain area, and right to counsel may be an area that we need to spend a lot of time focusing on. So any last thoughts, any comments? What we're going to do then is adjourn this portion of the meeting. We'll take a 10-minute break, and then the Human Rights Commission will begin the rest of the agenda for today's meeting. So please stay if you can. We have riveting minutes to review and some other really incredibly fascinating things. So stay with us if you can. And otherwise, have a great day. Thank you. We'll now resume the Human Rights Commission meeting, and we are at item 4 on the agenda. Items for discussion and action. The first item, 4A, is approval of minutes from the Commission's meeting held on January 22nd, 2025. You all received a copy of the minutes prior to the meeting. Are there any corrections or amendments needed to the minutes? If not, I'll entertain a motion to approve the minutes.
Approve the minutes. I don't know how to do this.
Marcia moves to approve the minutes, and I second. Daisy seconds.
All in favor?
Aye.
Say aye.
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 Any opposition? All right, the minutes are approved. The second item, 4B, is to discuss and potentially approve the resolution to remove discriminatory language from Oklahoma City plats. And I will ask Emma Winiski to give us the background on this. This also was supplied to the commissioners in the material prior to the meeting. And Emma, I'll turn to you and ask you to give us some background information on this.
Yes, okay, hopefully this is working. So basically, across the US, this is not a new initiative. Many plats historically had discriminatory language that sort of allowed landlords or owners to not rent to certain protected classes. And obviously this is no longer legal, but many documents, including some of those in Oklahoma City, still contain harmful language. And so recently Edmond actually, and at the state level, there is a statute that allows municipalities to work to go through the process of amending plats to strike this language. And so Edmond, I think, just did their first plat amendment earlier this year. And obviously the scale as far as the number of plats that are affected in Edmond versus Oklahoma City is quite different, but we are interested in sort of pursuing that here. And so there's a slow process of like mailing a letter to every homeowner in the affected plat, and then Planning Commission has to hear that, since they are the body that sort of manages those, and then City Council accepts those approvals. But really, this is an opportunity for the Human Rights Commission to sort of get that ball rolling. Council will hopefully also accept a resolution to sort of initiate this process as well. But this is such a great opportunity, obviously, given the nature of our commission and the work that we want to do, to be a part of a citywide initiative, or city and county-wide initiative, to sort of look into this. So I'm really happy that we're included in this process, and then I think there will be other opportunities for us to support the actual implementation of it, because signing a resolution is one thing, identifying the plats, going through the process and the logistics of actually getting this corrected will be a different sort of operational challenge. But I think that, again, we have convening power. I think we have various connections to our networks in the city. I think this would be an amazing kind of like opportunity for education, to like sort of organize some action, which would be exciting, I think, at least personally, and I think for the commission as well. And another chance to kind of get our name out there and sort of say, this is again, beyond just the educational things that we do. Here is something where we can invite residents, advocates from the community, and to be a part of this work together, and we would be sort of leading that effort. So I'm really excited about this. I've already, been on the phone with some folks at the county, talked to some folks in Edmond, talked to our great staff in planning and municipal counselors about sort of the how-tos of this, but this work will continue, and I think it's a great opportunity for the HRC to sort of get it kicked off.
So these restrictive covenants affect not only tenancy and occupancy, but also ownership. So they're very broad in nature, and they're typically explicitly racially discriminatory. Some are religion, discrimination against certain religions. Do we have any questions about the resolution, the wording of it, the purpose of it, the implementation of any follow-up. This is, like Emma said, I view this as an opportunity for us to not only make a statement, but also take action, because perhaps we could be the body that organizes the volunteer work that will be needed to actually review the plats and submit paperwork for their amendment. So I view as one of our core opportunities for the coming year.
Well, I think that was going to be my question, where the work fell, whether it was with staff or whether it was with HRC, but it sounds like we're going to do some ad hoc committees or advisories to do this work.
Go ahead, Emma. What does the city envision our role to be?
So, so far, I've been trying to do a little bit of research just again about the process, because it's been so uncertain. So again, like if this were to get started, there would be a process of identifying the plats, because we can't make the assumption that every plat before 1968 had this language. But we will have an idea based on either, let's say, maps of redlined areas that we know exist, or just like general areas of the city where we might be looking. The plat documents are like old documents that are written in like, you know, that old cursive handwriting that are a bunch of PDFs saved. So there's no, unfortunately, quick way to like pop them into AI, for example, to have them search for things. So it's a very manual process. So when you say where the work will fall, I think some of it for that initial identification process and the strategy of how to phase this could fall with the HRC, or we could organize people to literally like potentially look at the plats and start to identify which ones would be eligible for amendment, or to come up with a recommendation about how to phase this. So like if we want to focus on those existing redlined area maps to start, that would be one approach. If we wanted to do one big swath of looking through them and identifying, then phasing it, another approach. As far as once we identify the plats, you have to send a letter to, again, every homeowner within 30 days, or you can give them 30 days notice for the next planning commission meeting, because the planning commission is the body that is in charge of officially sort of amending all the plat stuff. So we would be working with staff in our planning department and probably PIM as well to like get those letters mailed. So that would likely be a combo of like me / other city staff. But I think in that initial phase, which is the heaviest lift and is likely beyond staff capacity right now, that is a huge opportunity for the HRC. And then any awareness, I think this is like a huge opportunity for us to engage with like, I know plats aren't aligned to neighborhoods, but I think it's a great opportunity for us, and excited to hear from Brian and Ralph about like getting our name out there, engaging with some of these existing and well-organized either homeowners associations, neighborhood organizations, especially if they're in an area where the city will be going through this process, to say like, hey, this is what's happening. You maybe got a letter. You're probably hearing a lot of different city groups, but like here's what the HRC is doing. So that would be another like work item for the HRC, but I think would be in line with some of our strategic goals.
I'm really excited about this work. I loved it when Edmund did it. I liked it when Norman did it. And I want to just say to you, Emma, like, good job, right? Because you think about the things and you put them into action, and we keep talking about doing something, and this is something. So thank you.
I want to, thank you. And also, this has been brought up by other city staff. Other assistant city managers have also received complaints. So you're sweet. And also, I will give a vague shout out to the many city staff who have like fielded these requests over the year and been a part of this effort as well. So team effort as always, but
awesome.
Excited for this.
Any questions or thoughts, Ralph?
My question, who would then change these?
The Planning Commission would ultimately
Say that again?
The Oklahoma City Planning Commission would
The Planning Commission
ultimately
would-
have the authority to make amendments to the plats.
Okay.
And then they'd be filed with the county clerk's office.
Okay, so are we talking about everything pre-68? Is that what it mostly is?
Hopefully. We can't imagine that there would be post-68 restrictive covenants, but there could be. I don't mean to eliminate that from our inquiry, but it's going to be primarily investigating the covenants that were put in place prior to that date, because the U.S. Supreme Court made it clear that they were illegal at that date.
Exactly.
Yes.
Is there a place, Emma, that we can get examples of what you're referring to? My question being that I'd like to see what that is compared to where I live.
Yeah, sure.
Can you send me that at another time? And then that also then leads me to my final question would be, are we adopting this resolution in its entirety, or are we going to discuss this over a period of time? And the reason I say that, and this is from the gray hair, is that my time with resolutions is over about a decade, and sometimes they work against what we intend them to do. And that's just a Ralph thing. I'd be very careful about resolutions. I have no problem with any of this. I just want us to, as you have said on a couple of occasions, to be the mediator or be the steadying force. I want that to be here, but I don't know enough about this to put a stamp of approval on it without knowing what it looks like to me. And I know that's very vague.
What do you mean it?
I want to see where pre-68 looks like to what my covenants are.
Are you asking about the wording of restrictive covenants?
Yeah, I want to know how horrific it is.
Well, they exist currently in plats across Oklahoma City.
Okay.
When you say horrific, I'm not sure what your level of concern is.
Would you like to see one?
I would.
Okay, we can get one for you.
That would be fine.
Just
That
to
would
show
be
you
good.
the wording on.
Yes,
the
I'm in a brief conversation I had with Brian last night, we were both in agreement that this needs to be nipped in the bud in going back in history and doing that.
So you're in agreement that
Yes, I just need a bit more information because of my timidness about resolutions.
Could you articulate what your concern is about the resolution itself? And let me pause, because would it be helpful for me to just read the resolution on the record, read through it?
I think that would be helpful some. Yes, I do.
Well, I can do that if that would give everyone time to think through exactly what we're.
Well,
everyone's received it, but we can certainly read it into the record.
I'm not making excuses. This came just right at the beginning of spring break, and I got it. I think that was right. Isn't that about when we got it? Or was it after?
Like a week before the meeting?
Maybe.
I don't know if that was your spring break
it's fine.
week, yeah.
And I have read over it, and the first thing that jumped off the page to me is that, yeah, we need to do this. I just don't want us to tell me this is going to be an ongoing thing. Is it going to be an ongoing thing, or are we just going to jump in here and do this?
What do you mean, whether
Well,
this is going to be
something that we
an ongoing
tackle
thing?
as we go forward through 25 and 26, individually of these things.
What we anticipate is that we will organize certain either educational events through neighborhood associations or volunteer events where people can actually come search through the plats looking for restrictive covenants, identifying those that need to be amended. That's a lot of labor, but we could organize a volunteer event to help the city accomplish that work.
Okay.
So in that regard, it would be ongoing. The resolution does not state anything specific like an event or work. Would anyone like for me to read through it? Brian, what's your thought?
it might be helpful maybe moving forward is to define what the workload looks like, because it sounds like a ton of work to me. I totally am in agreement with what's stated on the resolution. We could all stand behind that, but it's kind of the next steps that I don't know about it. It's like, okay, that's fine if there's a group at the city that's going to start researching these, bringing them to our attention, we can look at it, and then we can file for an amendment. But I don't know exactly what it looks like to us as a committee, workload-wise, and then how do we take it from identification to resolution?
Okay, so that's a good point. I just want to emphasize that the resolution doesn't specifically describe whatever actions we would take, like speaking at events or helping with the actual work. We would have to have more information from the city and coordinate our efforts with the city in order to make that
Do you think
decision.
it's something more along the lines that we bring it to the attention of the community and they let us know if they see some problems with certain plats and things like that? Or are we proactively going out there and researching the plats on our own?
Someone coordinating with the city will affirmatively go out and search the plats to identify it. We wouldn't rely on word of mouth from neighborhood associations or anything like that.
Okay.
It would be detailed work, but the nature of it and the timing of it are to be coordinated with the city.
Is this on? Okay, it's on. Okay. Maybe I'm being too, and it might be my experience organizing volunteers and organizing and coordinating and doing this type of work. But I think that the city's going to take this on whether we're a part of it or not. And I think this is a great opportunity for us to be a part of it. We've talked about action, and we're talking about actual change in our community and things that are needed from the HRC. And so I think that this is a great start, and I feel like it's generous of the city to let us put our name behind it as the HRC. And it's something that needs to be done. Like, this is, you know, we talked about how one thing might not affect you, but in reality, there's so many trauma behind things like this, just language and plats. Like, this is a psychological, you know, impact and trauma for a lot of people. So I think it's generous of the city to let us, you know, have our name behind it. And then I do think that strategizing, and this is not saying like it could be a lot of work, but it could be also phased out. You know, if it is a lot of work, it could be a volunteer event where we're bringing in people with the city's help.
Yeah, I'll say this. Hello. Off? Is it off? Oh, shit. Is it on?
That sounds
better. Is this on now?
Yeah.
Oh, okay. Yeah, I'll say technically the city manager can just tell us to do this, and I've spoken with both him and the mayor explicitly about this, and they're both in support, and they both thought it would be smart to give us an opportunity to do this. So I agree that, like, they are being nice and trying to loop us into this work. Craig could just tell me tomorrow, and we've already had conversations. That's why I was doing all this background work. They're pretty much ready to move forward. So I want to, like, be mindful of that, and they're obviously cautious about staff capacity and workload. Again, to your concern, there's nothing binding about what the commission is responsible for, and in fact, this is like largely symbolic for us because it's really the planning commission and the folks who coordinate with the planning commission who will be doing the nitty-gritty of, like, the letters, which again, we have a template from Edmund, so hopefully we can make the process as efficient as possible. It would be like if we wanted to opt into trying to be more active in, again, some of those early identification of plats where we could choose to sort of step up to the plate to sort of expedite the process. Because if it's only reliant on city staff to, like, comb through, like, thousands of PDF files, that is going to take a long time. So I think this is, again, largely symbolic in support of this process. This alone would not kickstart it. Basically, City Council would pass a resolution referencing this resolution, initiating the process again, which again is even slightly symbolic because the state statute doesn't explicitly say that council has to do it. I think everyone's just in agreement, like y'all said, that this work should be done. There's no point in having this. It's causing harm to people who see these words that have no legal standing. So as the Human Rights Commission, it's just another chance for us to, again, tack on to this work and be a vocal sponsor of its importance.
Any other discussion before I call for a motion?
I'll make a motion that we adopt.
All right, Ralph makes the motion that
Second.
we adopt the resolution.
Daisy
seconds.
seconds.
All in favor, say aye.
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 Any opposed? All right, the motion passes, and we will sign the resolution. I will sign the resolution today in accordance with that vote.
And I will keep y'all posted because now on my to-do list is to basically send a draft of the council resolution that will be the pair to this to Craig and the mayor. So again, I think this will be on the city council agenda at some point, and I will let you all know the date of that if you want to follow along.
All right, thank you. Item 4C, the nomination and election of the vice chair of the Human Rights Commission. Under our bylaws, the Rules and Governance Committee acts as the nominating committee for the vice chair. And I will call upon Leslie Van Buskirk to address this matter.
Yes, the Rules and Governance Committee is very pleased to nominate Dr. Marcia Heron for the position of vice chair.
And in accordance with our rules, I will take nominations from the floor if there are any. Any nominations from the floor?
I make a motion nomination cease.
We'll close the nominations, and all in favor of electing Marcia Heron as vice chair for this year again, thank you, Marcia, say aye. Aye. And any opposed? All right, Marcia, it's by acclamation that we welcome you as vice chair again. You've done a wonderful job since the inception of our commission, so thank you so much for continuing in that position. All right, compliance officers report.
Okay, so since our last meeting, we've actually only had one complaint filed, so that's a low number based on other sort of reporting periods. It has been referred out. It was not within our jurisdiction, but that individual has been referred to an appropriate organization to file their complaint. Our annual report was drafted and sent out. You all should have received that. Pretty quick read. Nothing should be a surprise because we try to keep it brief for everyone. It's been sent to like Craig, the mayor, city council, some of our friends at the AG's office. So we are good to go on that. Thanks all for reviewing it. Dean Couch mentioned earlier that we'll be hosting another Tenant Know Your Rights training in April. That is a partnership with Metro Fair Housing, and if you were at our meeting last July when Mary Doolin Daniels was one of our panelists, they do great work in fair housing and are a community advocate, and they reached out to us to see if we could partner, and so we are hashing out the details on that, but again, we will be in communication about the logistics of that meeting. It's obviously outside of our regular meeting cadence, so it won't be by any means an official HRC meeting, but again, this is another opportunity for us to actively partner with a community organization to increase our community presence. And I personally, as a tenant, found Adam's presentation incredibly useful. So I'm hoping that, especially for Metro and some of their clients as well, this will be another good opportunity for people. And it's Fair Housing Month in April, so obviously a timely event. So we'll keep you posted on that, but we're excited to partner with them and again, have Adam come present. And then the last thing is the Latino Community Development Agency, LCDA, is hosting a legal clinic on April 5th. And the city will have a presence there for multiple things like our Action Center, which Joy mentioned earlier. I think we'll have some information for folks. The HRC will have some information there. And then some of our housing and community development programs and planning that provide grants for like housing rehab or rental or down payment assistance will be also tabling there. So thanks to Daisy and Jonathan for helping translate some materials for us. We're just getting those prepped up. Again, LCDA reached out actually to the mayor's office to see if they'd be willing, and then the mayor's office was like, let's see if HRC would like to get involved. So another opportunity, it's a Saturday, just for us to sort of partner with other community organizations who are doing good work and to provide some information about what we do and how they can be engaged with us. So nothing needed from you all, just want to give a little bit of awareness and visibility to the work that LCDA is doing, and we're grateful for the invitation to kind of set up a table there. So I will be there stumbling through my high school level proficiency in Spanish, so maybe Jonathan can join so to help me out. But yeah, we'll keep y'all posted if there's anything that comes out of that that requires like follow-up from us. But again, just excited to be getting out in the community, partnering with some groups who we know are doing good work, and to reach, different populations. But that's all I have.
Any questions for Emma? All right, 2 quick related points for the chair's report. The April event is tentatively set for April 25th from 5:30 to 7. Metro Fair Housing will be identifying the venue. So we are in a bit of flux, but if you would pencil in that date and time, I would really like to see most of us, all of us if possible, attend that event and participate with that community. So the other item is to remind you that we're putting together for just internal uses, a directory of the commissioners with updated contact information. If you have not given that information to Emma yet, please do. We're trying to get that directory to everybody. There have been changes in email addresses or phone numbers, and we just want to give everybody the best contact information for our internal communications. All right, let's move to item 7, strategic goals for 2025. And we'd like to hear from a number of our groups who are working on our strategic goals. The first is Communications Committee. I know that Ralph and Brian have been working on taking the items from our strategic plan for 2025 and actually put them in a form where we can take the next steps for what we want to accomplish this year. So Ralph and Brian, I'll turn it over to you for your report.
Ralph, I'll jump in real quick. We provided a handout that kind of goes over a top line overview of kind of what we see the marketing plan is going to develop into over the course of the year. Obviously, our focus for 2025 is housing and public accommodations. So that's kind of where, going to be obviously our one target out of all the issues that are out there, but that's one we really want to communicate out into the public. Our objectives overall the key is going to be identifying target audiences within the entirety of the city. There's a position you can take that you want to communicate to everybody, but I think what we'll find in 2025, what Ralph and I have discussed with Valerie as well, is just kind of identifying some pockets and some targets that we can network into. So those could be homeowners associations that might be able to disseminate information to a larger audience of their constituents, and kind of taking that approach. And those can be nonprofit organizations, the homeowners associations, outreach groups, the people that present to us. They all have a base of population that would be key for reaching a target audience. So we're going to work on kind of identifying what that target audience looks like, then using this network strategy to identify the organizations and ultimately increase the HRC's visibility in the public. let's see. So our communications goal is really going to be building a community engagement framework that increases our visibility. So again, it's just going to be networking and counting on the commissioners to all commit to going out and talking to organizations maybe in their wards or throughout the city, and communicating what we do, what the HRC is here for, and then also what our resources look like. And I think ultimately that's going to look on our end, that's going to be, again, counting on them to disseminate additional information electronically to their population base that they work with. So some of our actions and tasks that we've discussed is reviewing the HRC's website to identify what content's lacking, what resources need to be posted, so that as we go out into the communities, ideally we're having them come back to our website and they can look for their specific issues and find resources or figure out how to get in contact with us. One of the things that we think that needs to be established is working with the city to figure out the website analytics, so we can figure out kind of, are we doing our job? So some sort of statistical analysis that says what pages are they visiting, how many people are coming, and as we go out into the communities and spread the word, is our traffic increasing? Are we seeing any results? So in order to kind of establish a baseline, we'll do that relatively quickly to establish that baseline, and then we can kind of watch it moving forward to see what the traffic's looking like. Social media posts is on here, and I think what we just need to do is put together a timeline and topics for social media posts that the city can, since we don't have our own social media and we have to count on the city to do it, we'll put together a time frame of topics and when those social media posts can go out, and hopefully that'll help drive traffic to the website and our resources. So let's see. One of the things that we've discussed with Valerie and we discussed in our last meeting was putting together kind of a toolkit for the commission as a whole that identifies talking points, resources, how we want to direct people to the website, and when we're communicating with organizations, what do we want that to look like? We want it to be easy and quick and easy for all the commissioners, something that we can all just go out and briefly talk with an organization and get our point across and have them, again, do a pass along additional information to their base. So we'll be working on a toolkit that includes the talking points, presentation guides, handouts, and electronic pass along materials. Another thing we've discussed needing to establish is a media plan, and that's not, that isn't going to be a traditional media plan, but it'll outline our social media posts, what those topics are, what organizations we're talking to, when are we talking to, let's schedule them out so we're not heavy in one period and light in another, and we're not counting on one commissioner to be out 5 times in a month talking with a group. We want to spread it out and look at the full picture. On top of that, we've discussed there's news organizations and in traditional news where we might be able to go out and speak to the general public, and those are things that we'd want to organize and get posted on that media plan as well. Let's see. That really kind of covers most everything. I think we've talked about everything that's on this sheet. One of the things that Ralph and Valerie and I talked about is we wanted this to be kind of an evolving plan as well. We want your all's feedback. We want to know if you all feel like we're out of line or if we're missing something. Is there a topic that we really need to touch on that's outside the 2025 focus of housing and public accommodations? And sometimes it's going to depend on which organization we're talking to. So that's kind of our summary, Ralph, in this. Anything?
Thanks, Brian. You did a great job with that, summarizing it all. The thing that I'm most concerned with is that we get a bit of a message out to people that we know. For instance, over the last 6 months, I've been asked to speak on HRC twice, and it's only because they know I'm on the commission. And I have just kind of made up my own little outline that I have in my satchel at home, that I just go through, here are the things that we look at, what we have done. And I usually use Emma's information from the previous report as to how many we've done. It's obvious to many people that, or they think that we've had this huge influx of problems that come into us, and people want to know, well, what do you all do with them? They actually have the perception that we handle it and that we don't send it to an agency that knows what they're doing, or we have people like Emma and our staff to help with that. They don't know that. And it's those things, they don't want to even get into the weeds in it, because I certainly don't want to go there with it. But presentations are important, no more than 10 or 15 minutes max, because that's what they're allowing you. And that's kind of what we're going to be working on, if that's okay with you guys. And hopefully in our May meeting, they will give you some outline of what that looks like so that you can start. That's what our goal has been.
Let me ask about that toolkit that you're talking about, and perhaps we will see some of that in the May meeting. Is that your time frame for accomplishing a toolkit, or is it a longer time frame?
No, I think that's, by next meeting, I think that's totally fine. I mean, I think we're moving so far into the year at this point that it either becomes action in 2025 or we make a 25-26 kind of thing.
Yes.
And maybe it'll push on into 26, because again, I think we can yell to the masses with media. It's kind of like yelling into the wind, I think, at this point. So I think really taking the network approach and being a little bit more detailed in our discussions. And like Ralph said, I don't think this is going to be a complicated packet. I mean, it's some talking points. People don't want to listen to us talk for, an hour. They want to, know who we are and what we do, and get a couple of bullets, and let's pass along the information that we are a resource, and this is what we do.
And will that include something to hand out to them or to pass along electronically?
I think so.
Okay.
I think so. I think that's all reasonable to have. So I think what we can do is bring that to the table for approval reviews at the next meeting. And if everybody likes it, we'll start scheduling out meetings with some of these organizations and kind of define what our next steps are going to be.
I'm curious to know the commissioners' perspectives on creating an expectation for each commissioner to take on these presentations, go out into the community. What do you think would be a reasonable expectation that we create for ourselves?
I can give an example. I did a Crown's Tea talk at Ralph Ellison, and the purpose of that talk was to discuss evictions in 73111. And so during the course of the conversation, we got to the part where we talked about do something. And at that point, I was able to say, I'm the Human Rights Commissioner for Ward 7. And people were like, what? What is, And so this is what we take up: housing, public accommodations. Was able to put in my presentation the website, and say, this is a resource if you have a complaint, we have a process for that. If you want to come to a meeting, those meetings are posted publicly, but this is your way to come and address issues and do something. So as a call to action, I've done it in other conversations that I've had, or keynote address, where I'm like, and we have a Human Rights Commission. So I think that it's not unreasonable, if we serve on this commission, to talk about the commission publicly.
I agree with Marcia. And then before I forget my thought, but the only thing that I think with the call of action is also promoting how they can also be on how the process is to be a commissioner works. And because we are going to have a few seats that are kind of be available, and it's always a concern is like there's not enough out there of that. So then the council can make a recommendation for the commission. And so just kind of explaining what that process is, and maybe having somewhere where I know we promote the current positions that are available so they can sign up, but maybe keeping that open on the website so that way if interested people come across this and we can promote that and say, hey, we want you. Like, if you want to be a part of that and you want to be a part of that change, like, sign up to get more information on how you can be a commissioner, how you can be appointed to be one. And so I think that us not losing sight of that would be good, because we don't want to run into the, into not having a candidate to recommend.
And responding to Ralph's point about being a referral source, we are becoming a very sophisticated referral source, but hold in mind that under the ordinance, one other very powerful capability that we have is to provide mediations and conciliations. We are not known for that service, and that information needs to be out in the public so that we can really fully fulfill our mission under the ordinance. So that's another point, a talking point that should be part of this. This is a wonderful discussion plan and action plan as well. So I would thank both of you for your thoughtfulness and leadership in this process. It's essential. It's essential, and we appreciate it. If you need help, you can call on any of us to think through this. And Brian, you're a brand new commissioner. You've already jumped in feet first, with everything we're doing. But having some historic perspective on our first 2 years might be part of the process as well.
Yeah, it was helpful to go look at Rhonda's notes and things like that, and looking at the top line, the big plan, which is always interesting, is how that's defined. And I know that's been the past couple of years, but that's kind of why we wanted to rein it back and do something a little bit more precise.
Yeah. Well, we will look forward to May meeting and really refining the action plan that you've already
Could we have a few moments in that meeting to maybe, if we present our talking points or our toolkit, whatever you want to call it, that you all interject, and maybe even, Emma, we could put out an email between now and then to get your all's input as to what you think are important, some of the talking points. I have in my head what worked the second time that I talked before people, and I do want to entertain the mediation part of it, because I didn't even go there. But we need to have your all's input, and if Emma could put out, when she puts out her deal beforehand, say, hey, listen, send us a few of your ideas, and then Emma can pass that on to Brian and myself, and we can put it together in a couple of days.
Yeah, I'm happy to do that. I think that's what we did with the mission and vision of just sending them out ahead for review. I think what's most helpful always, I find, is giving people something to react to. So if you all would take the first pass at, drafting something, happy to share that with commissioners and then sort of consolidate and synthesize any feedback so that we can have a productive discussion during the meeting and hopefully sort of like come to a consensus. I see one other thing on here that is like rings the alarm bell for Emma needs to do something, which is the website visitors analytics. I've messaged our friends in PIM to just see what all they collect, so I will let y'all know as soon as I hear back about that. But I think you're right to get a baseline so that we can see if how much of an impact we're having once we start to sort of go on out there.
Yeah, I think it's going to be important for us to at some point establish our performance. Not on the communication side only, but I mean, maybe how many people are calling in, how many referrals we're giving, how many mediations, but definitely from our perspective, if our goal is ultimately to drive, inquiries in and to generate awareness, I think that's going to be an important piece.
And we work through that information on our annual report. But the question for the communications committee, I think, is how best to communicate that. Right. The annual report is available on the website, but it's specifically designed to give the city council notice and the mayor notice of what the commission has done in the prior year and what its goals going forward will be. So let's think about the annual report as kind of an used resource right now, what we can do to make it a part of our communications plan.
Cool.
I'm also tracking so we have like a digital form. I have received maybe one paper form, and then sometimes it's different emails or phone calls. So I track all of that and then report out here. But if you know you're going to go speak somewhere and you're like, Emma, what is the most updated number or something? I have a up-to-date spreadsheet of that, so you can always just ping me, and I'm happy to give you the most up-to-date number if you know you're going to go out and talk.
Great.
Okay. All right, well, we'll look forward to May, and that'll be a really productive meeting for us, I think, internally, for sure. Education and Outreach Committee, Cindy and Marcia, would you
I can do it.
give us a report?
Yeah, I mean, we just saw Adam's great presentation. So that was our big education event for the year. However, like Emma mentioned, in April, we are partnering with the Metro Fair Housing for Fair Housing Month. So Adam will do the exact same training, hopefully with a little bit bigger of a turnout as well. And then, as always, I wanted to promote that training. So if you are in touch with any nonprofits or organizations that want to have that training brought to them, Adam does that as well. I also have a bunch of the brochures that he left behind. So if you know organizations or you want to take a bunch with you, I have them right here with me. So that is what we are doing as the Education Committee, just a bunch of tenants Know Your Rights trainings. And then I'm sure we will discuss something maybe for December and International Human Rights Day. We're still kind of discussing what that looks like. But right now we held our official training for the year.
Mm-hmm. Anything additional from Dr. Herron?
Nope.
All right. I noticed one other item on our strategic plan that does relate to the education outreach, and that is an event focusing on public accommodations. That is our secondary focus for the year. And so we look forward to seeing your ideas about focusing on that as well. Is there any, I guess my mind is going toward assisting the communications committee with your perspectives on the education and outreach we've done so far, and how communications on those events have worked or not worked, and how we can improve all of that.
I think it'll feed in nicely to the impact data because we do these programs, and maybe attendance or maybe some whatever pieces of data that we collect connected to the education programming that we do is going to be important for the community to be able to see. But like Cindy said, definitely some ideas coming toward the December International Human Rights Day, because I just wrote down an idea that I'm not ready to share yet, but.
We know your mind is always whirling.
I'm like, public accommodations, I think I got something for that. So we'll get into our follow-up meeting and then just kind of hash it out. So,
okay, great. I've asked Daisy and Cindy to serve on an ad hoc committee to address some special issues, and I'd like for them to report on their work to date.
Yeah, okay, we're gonna do this together. And so Cindy and I met and we discussed our goals for this upcoming year on advocacy, focusing on advocacy. And one of the tasks that we're working on is setting clear protocols for when and how the HRC will make public statements related to human rights. And so I think that this came up a lot last year, where we were discussing when does the HRC speak up and send out a public statement, and obviously working with the communications team on that too. But there's a lot going on, and there's a lot of issues. And so Cindy and I recommend that we stay focused on our annual goals, which is housing and public accommodations, but not limiting it only to that, and having a clear process on how to bring other issues. So let's say that there's an urgent matter that happened in our community, which is happening every day. We wake up, but there's something major going on, and the community is expecting us to speak up or say something about it. And for us, it's like, how can we set a process where we don't signal one issue being more important than the other, and we communicate something, and it could happen. We can really be public about one opinion and then something else happens and we just completely miss it, not because we didn't want to be vocal about it, but just because it happens. And there's so much, and there's so many branches of things going on in our community. And so we came up with the preliminary process, and we want to bring this to the committee to get your feedback. And obviously you can let us know here or via email on what you think of that. But the process would be that the ad hoc committee filters out issues that are brought to us, either by you all, by Dean Couch, Emma. There's something that comes to you all that it's like, this is happening in our community. Believe the HRC should look into it or speak out on it. So we filter that out. We kind of go through that, and we use a rubric. And I think the best and cleanest way for us to do and filter those issues out is using a rubric. And the rubric will include, we don't have it yet, but we're thinking of including the rubric will have how the issue aligns with the HRC scope in the ordinance and what we can or cannot do, the capacity for both commissioners and communications and resources, either us, the communications team, or the city's resources. Then identifying a speaker. Do we have a speaker available to publicly speak on this issue? The urgency and timeliness. There are some issues that require us to respond right then and there. If it doesn't happen, it just kind of floats away. So the urgency and timeliness, the impact on our OKC community. And then this one is, these two next points are really important. It's community interest and outreach. So the number of residents and organizations that are reaching out to us, wanting us to respond or want to get our thoughts on it. And then partnership opportunity. And so we included this in the rubric because a lot of what we're gonna get might not fall within what the commission will do. We don't have the resources, or it's just, we can't really respond to every single issue that's going on in our community. So we wanted to get a positive spin on it. Okay, you might not publicly say something as a press release or something like that, but what can we do? And so I think this goes back to who reached out to us. Is it a partnership opportunity? And then we will strategize. So depending on the outcome of that rubric, if it has a high enough score but doesn't have it high enough for us to publicly speak up on it, we can then go back to maybe the Community and Education Committee, or even us, and bring back this issue and say, we can't do it, but let's partner with someone. So with LCDA, we are not publicly, speaking out on the anti-immigration things happening in our community, but we are partnering with LCDA by providing resources and maybe promoting the volunteer opportunity. And so just having that positive spin that although we might not be able to publicly say something and do something about it, that we can partner with these organizations that are doing something about it. That's kind of what it is, but strategizing, and then we have some steps of if we do end up saying that this is an issue, of going back to the commission, going back to Emma to let you all know before we release a statement, so you're comfortable also with that statement. Did I miss anything?
No, I think it's on now. Yeah, so I think you got everything, Daisy. You went over the full the full slides, and like Daisy said, we are creating a rubric pretty soon in our next meeting, and it should be ready around May. So we did want to establish the clear protocols in the rubric, because when we say we're part of the Human Rights Commission, people think of all types of things. The community often doesn't know what our focus is, that it's housing and public accommodations. If you're not going to the meeting, if you're not following them on social media, oftentimes they have no idea that we even exist. So hopefully a part of this is if they do come to us about a certain human rights issue, that we have clear-cut protocols of when to speak out. And if we can't speak out, we can still partner with organizations that are already doing the work.
I have some questions. One, there appears to be a significant amount of overlap between this committee and Ralph and Brian. And so I'm not sure, and I don't want to plant trees for people, as my mother would say, how beneficial it is, but it appears to be if maybe one of them joined the ad hoc committee with you all, because as you're deciding, a question that I have is who gets to rate the conversations through the rubric? Is that the entire commission, or is it just the committee? Because we all carry different perspectives, right? And so maybe something that's more important to me, and might not be as important, right? And so, not that we all don't think alike, because I know we do, we love roses and stuff, but how do we make those decisions? And
I think the key here is going to be the rubric, to eliminate the what does Cindy think, what do I think, and then we talked about who gets involved in that process and making that decision, and we, just saying, I was like, I want everyone's input. But realistically, when you have these type of issues, that the timeliness and the urgency, like it's not realistic for us to call a meeting and have everyone else decide like what we're doing that. And so I think and it's challenging, right? But the key here is the rubric. And so we want to create a rubric where we eliminate more of like my bias and how I'm bringing in my thoughts into it, and more of like, this is the amount of people, 20 people reached out versus one person reached out. Like we're adding things like that it's like, here are the facts and the things coming to us versus what my thoughts are as me, Daisy, in the community. And this is what I do. And I think bringing in someone from communications, I don't have an issue at all, bringing them. I do think that they are already helping with another goal that Dean Couch had sent over to us. And when it comes to communications, I think that's their realm, and that they'll be, have input in that aspect.
So in terms of process, it's a good question, Marcia. An ad hoc committee is not a standing committee.
Right.
It can exist for some period of time to accomplish a project designated for that committee, and then, if appropriate, the subject matter of their work can move to a standing committee, like the communications committee might ultimately be the point, they might be the point people for working through the rubric. The rubric is very important, and I can't overstate the importance of having a thoughtful, careful process before making a public statement. I work with universities on this same issue, and they sometimes are asked to take a stand or take a position on a controversial issue. And if you do not have a process in place that everyone agrees is appropriate, then it can lead to very unfortunate results. So I've asked the ad hoc committee to really just bear down on this. Whether it stays with the ad hoc committee, I don't know. That I think the chair can make that decision about moving the ad hoc committee's scope of work to a standing committee if appropriate.
So is the charge then to just create the rubric and then the potential to move out to communications? Okay.
Yes. But I envision all of us working on the rubric, that it becomes a draft that we all discuss and think through. It's very important, and obviously to get our municipal councilors involved in this process as well.
Okay. Yeah, I was just trying to understand better, like the involvement for the commission or where the decisions would be made. And then to streamline the work for communications, because didn't want them to be doing the same thing.
You can see from our strategic plan how overlapping all of the committees become and all the work. And it's nice in a way to be a small commission. We have 9 members, so it's not an overwhelming number. We can communicate with each other pretty well, I think.
Can I ask a follow-up question to that?
Yes.
When we talk about community members reaching out, is there a process? Is there a process for us, if somebody reaches out to us,
what would the process be for us to report that to the ad hoc committee who would then use that as part of the rubric? I mean, is there a process, or will you develop one? You know, my ever pragmatic mind is like, okay, well, how do I do that?
So your question is, when you might be asked to take a stand?
Well, no, we're talking about the number of people who have expressed a concern, but obviously they're not just going to express a concern to the 2 members of the ad hoc committee. They might express it to any of us.
Yeah, and that's coming from you. And I think it goes back to our goals of promoting and being out there in the community and let them to know, like, this is what I do. So Marcia being out there and saying, you know, I'm part of the HRC, let me know if there's any issues, or, you know, come to me. I think that comes to us putting ourselves out there and telling them. And so if you do hear of this, we'll create a process where you can either, and we're thinking through those details, you know, and that's why we brought it up here.
Yeah.
But you would tell us, it's like, hey, I already had 3 people reach out to me and about this. Like, this is what their concerns are. These are, you know, what they're bringing forth. And I just want to bring that to you. And that's where it would be a part of that rubric. We'll put that in the rubric.
And that was my question. I'm just ever pragmatic. How does it actually work? And thank you.
Yeah.
All right, any other discussion of the ad hoc committee's work? We'll again look forward to an update in the May meeting and perhaps work on that rubric together. We're in item 8 of the agenda, remarks and announcements. And we first turn to members of the public. And Joy Reardon, you have indicated a desire to talk to the commission, and we welcome you and turn it over to you. I'm sorry? I'm sorry. I'm not going to announce her.
Make sure I don't go bang.
I hope that's on. Can you?
It is.
Oh, yes. Okay.
Whew, good. I don't know the exact procedure, but it's city council. They have you say your name and where you live and stuff.
That would be appropriate for the record. That would be fine for the record.
Okay, Joey Reardon, 125 Northwest 9th. I got 3 items. Nowhere have I seen that on any of the commissions or whatever, any ADA members, any members of the ADA community. Why is that?
Why are they not serving on the commission?
Yes. It's all able-bodied people. It's like, and the other one is the ADA seems like it's the third rail. Nobody really wants to talk about it at all, whether it's housing, whether it's in the community, nothing. And it's really frustrating, especially for me, having to deal like right outside here when I got here today. You've seen it. The fence was pushed out into the sidewalk. The scooters. God knows how many I've actually had to move out of the middle of the sidewalk, out away from fire hydrants, out away from the middle of the ADA ramps, or where people need to get over and push the button for the ADA to cross the street. The other thing is better for the homeless. Yeah, it's great that y'all are putting them in housing, but where's the support for them after you get them off the street? Nowhere. Their counselor or case manager or whoever it is may come see them every 3 months if they're lucky. But it's just, it's something that needs to be looked into, seriously looked into. the three things that I brought up. We're doing a lot better than a lot of the other cities that I've traveled to, but we can do more.
Joy, one of our goals this year is to focus on public accommodations. And we will be planning and providing some sort of public event, a program for that topic.
Yeah.
Housing does overlap on public accommodations, obviously. To that extent, we're addressing certain ADA issues.
Yeah, I mean, if y'all need to, I have very little to do at home. Contact me.
Yeah.
And I will help.
We appreciate that
I
so
work
much.
with Embark on a lot of their stuff. And I'd be willing to work with anybody. I also went to school for architecture. And before COVID, I took the law class for the ADA standards. 2010, 2024, something like that, the new standards. And no, nobody is ever grandfathered into it. You have no grandfathers for buildings or anything else for ADA.
It's for new construction primarily.
No, any construction now.
Yeah. Well, we appreciate your voice, Joy, and I always enjoy when you come, and I recognize your expertise, and we will need and continue to pay attention to your
I've been in my
perspective.
chair since 2014.
Yeah.
So, and you also had another young lady here that was also in a chair. We don't consider these our chairs, we consider them our legs. This is how we get around.
And to speak to the commission itself, individuals who wish to serve on the commission can actually apply. There's a process for sending in
Where do
an
you-
app.
where do
It's
you
on
find the information?
Our website will have information about applying.
That's what y'all were talking about
Yes,
over here.
exactly.
Was where nobody knows. It's like a secret club or a secret knock that
Well,
you got to do.
We don't want that.
Nobody knows.
Yeah, we don't want that. We are doing what we can to make the process more visible, more open, and please tell you, I want to tell you and any member of the disabled community, apply. And the city council and the mayor are very involved in the selection process, but we can be of assistance to that process. So
Yeah, I mean,
please let us
a
know.
lot of the people don't know about even this meeting, or you would have more people here.
Yes, and that's really to our point about communications. There are public notices, and we do press releases as well. But we could do a better job communicating our programs and meetings
Yeah,
to the
I
public.
get an email from the city of different things,
Oh,
and
yeah.
that's how I know.
Yeah. Well, thank you
I mean,
very much.
a lot of people don't know that they can actually sign up to get email notifications
Yes.
of stuff going on. Like I get everything from there's a water main break up at wherever to the homicides each day.
Yeah, yeah. So that's a good point. There is a way to get notices very effectively through the city, but we need to make sure that's on our website as well.
Yeah, I get 5 or 6 notifications without the homicides for different stuff that's going on with the city because I'm so active.
Yeah.
And so I advocate for others that may not know.
Right.
And even where I live, and that's a whole different story. But I even let them know that the city council has to listen to you for 3 minutes.
Yes.
That's your right as a citizen, no matter if you live within the 621 square miles of Oklahoma City, you have that right to come down and fill out a piece of paper If you can't fill it out, someone will help you fill it out. And you have 3 minutes to bark at the city council.
That's right, you do. And we're going to protect that right too. All right, thank you, Joy. Any other questions?
I'll just say,
Yes.
Joy, I'll follow up with you because public accommodations, again, was listed as a topic that we wanted to focus on specifically because a mother came to one of our meetings and talked about advocating for adult changing tables for her son. And so just talking about, we are trying to be responsive to what we are hearing. So thank you again for giving kind of a +1 to the disability rights movement and the visibility. So I'll find you after this meeting so that we can connect because we need help, again, sort of knowing what best. We're happy to convene and find speakers, but we want to hear from community advocates and experts on what we should focus on. So let me find you after the meeting so that we can talk about that. I just want to make sure we close the loop there.
The other one pet peeve I have is the sidewalks.
Okay.
There's not enough, and two, a lot of the ones that are out there. See, a lot of people don't realize that a lot of the sidewalks, yeah, it looks great. But if you got like a half an inch to an inch of difference in the sidewalk, it could mean the difference between someone actually going down the sidewalk or having to go into the street and then onto the sidewalk. And with the sidewalk closed, a lot of these temporary stuff, a lot of the contractors and stuff don't understand that if you block off a sidewalk, you have to have signage stating that the sidewalk is closed.
Yeah.
ADA law.
I will also touch base. That's like contractor work. He's doing that outside. So I personally.
Trust me, the Action Center knows me by name.
I'm not sure who in building management would sort of handle that.
It goes back to the inspectors.
Yeah.
The street beaters, as they're called. The
But
ones that's
even-
actually going out and inspecting these jobs. And it goes back to the permit offices, because a lot of these jobs require permits.
Yes.
All right, well, Emma
I'll
will
follow
follow
up
up on this. Any remarks or announcements from members of the commission? And any remarks or announcements from our city staff who are here?
Just to remind everyone that legal, and speaking for Jonathan, who's perfectly capable of speaking for himself, but as your legal counsel, we work closely with Emma. If you have any concerns at all, please direct them to Emma, and as she finds appropriate, she will interact with us about it. Feel free to call us, but we will likely forward you to Emma as your compliance officer, just because she's kind of managing the commission, and we want to make sure that she knows everything that we are working with. Feel free to call, though, or email.
Thank you so much. We really do appreciate your time. You agree? Okay, excellent. All right, well, we are through our agenda for this meeting, and now we are adjourned. Thank you very much.